Hello, welcome to Notes to My Legal Self. The future belongs to builders. Together, we explore topics of interest to legal innovators. Know someone who'd make a great guest? Let us know. Self-nominations are encouraged. They're an act of courage. Want to get the most from this conversation? Ask questions, comment, like, follow, say hello. In short, engage. Lastly, have fun. Shaping the future of law requires significant effort, but finding joy in the process is essential. Let's begin. Here's your host, Olga Mack.
Well, hello everyone. Welcome to the show. This is the show that we were supposed to have a few days ago, but alas, I did not have electricity. And it turns out everyone in my house knew except myself. I talked to my husband. He told me that 5 times. Clearly, I have not heard any of those times. So we need to work on our communication. Clearly. And my guest and I got on this call and tried to have it, and he told me that I sound like I'm a mermaid or a robot or a duck, and I decided that none of those look good on me, and we're gonna do it better, and therefore we rescheduled. So without further ado, we're gonna have this exciting conversation. I'm really excited about this conversation because this is someone I knew for a long time who is doing some amazing innovation in the future of law. I would like to see more people like him doing amazing stuff in law and really up leveling how we law game. So I can't wait to have this conversation, and I encourage everyone to participate. And I promise I will not impersonate mermaid or a robot or a dog. Well, Eric, welcome to the show. Please introduce yourself.
Thank you, Olga. It's wonderful to be here. And I've been married for a long time, and we don't have any communication issues. We listen to every word. We're present in every single conversation, and we never forget what each other has said. So don't worry about that. It's a common issue. Hello, everybody. My name is Eric Voogt. I'm a longtime lawyer, trial lawyer. In fact, here in Denver, Colorado, managed a law firm for a long time, but started a legal technology company called Proof Technology about just over 5 years ago, and I am thrilled to be here to talk about technology and talk about the tremendous opportunities we have as lawyers to represent more folks that can't afford our services today.
I love what you're doing with Proof and how you productize this whole service of process. I'm a real fan of this whole human technology interaction you have going on. You did a wonderful job, and I really do want to talk about this on the show and how this could be inspiring for others. However, before we get into these juicy details, exciting details, tell me how Eric got up in the morning one day and decided to do this. Like you were practicing law, and it is not a
Yes.
common thought for most lawyers to get up in the morning and say, "Huh, let me build a tech company." How did this happen to a guy named Eric?
Oh man, when I hear you say that, I'm like, oh gosh, how did I do that? How did it come to me? I would say there was really two primary drivers, right? And one was very specific and one was more general. And I think they're both relevant to the conversation we're having today. From a general perspective, I was very frustrated as a lawyer, being constrained with this idea that you have to make money. Of course you do. You have to put food on the table. We've got maybe you have law school loans to pay back. You got a firm to run. A lot of people are depending on you. Somehow, there was just this tremendous number of folks that needed your representation through the court process that couldn't afford you, right? And it just was over and over and over again. People with just causes were not getting inside of the courtroom, and I have to tell them no. So that's a general sense that I had. Something had to be done, and clearly technology has to play a giant role in our ability to move the legal practice to a point where some of these folks can afford your services and get inside of the courtroom. Specifically, as a plaintiff's lawyer, as a lawyer that did a lot of big environmental class action cases, we had to serve a lot of documents. And I was just extraordinarily frustrated with the time and the money spent just attempting to find a process server near each one of your defendants, each one of your witnesses that are crucial to moving your case forward, and then not being able to get uh, regular updates without phone calls and emails. And that really spurred me on to start a legal technology company that first attacked that issue, right? It's a $4 billion total addressable market in service of process. Why is litigation expensive? Because we're spending $4 million just to get the darn thing started. So that was our first technology platform that we built, and now we're going to get into a lot of adjacencies. So I think there's that general reason, and then also the specific reason that led me to start Proof.
I love that. I love that you pointed out. It's interesting that you observe two things. One related to money pressures, and two saying no pressure. Those kind of go together. And most of us, when we think of access to justice, we think of kind of the first thing you mentioned, folks who would like to have their day in court, or they want help navigating a system that doesn't speak their language, and they can't afford to have a lawyer. And they basically either not pursuing it, or pursuing it pro se and not really getting the full benefit of access to justice. But I don't usually think of service of process as access to justice. I mean, you need to be in the game. You have to overcome, some sort of. You need to have a lawyer to be in the process business. You actually kind of see it differently, and I actually want to dive a little bit into it. Tell me how you see that, proof of service, which is when you have a bunch of documents you need to file, especially in the beginning, and maybe throughout the process, depending on consent of the parties and depending on what it is that you're serving. How is that, you know, an acute access to justice problem?
It's Look, it's the first thing that you have to do, right? When you filed your documents, and then the rules say you got to serve these on a bunch of defendants or on one defendant. You're like, what in the world does that mean? I have no idea what that means. First of all, they're calling you a pro se party. You don't understand really what that means. It's a Latin term. So just having an easier way to do that, which we provide, gives you access to justice. Otherwise, you're almost dead in your tracks at the beginning of the process because you don't know how to do this. You don't know how to hire somebody to do this. You don't know the rules behind it. We provide an easy one click button solution to that problem. So that's the beginning of my answer. The end of my answer is every time lawyers spend less time and less effort doing part of their case. This is the initial part of your case, or finding process servers to serve your witnesses. When you spend less time and effort, and our clients tell us on a regular basis or an average basis, our technology saves them, their paralegals, an hour to an hour and a half worth of time. That's for a plaintiff's firm, $300,000 to $500,000 worth of paralegal time over the year. If you can reduce that by $300,000 to $500,000, you're going to be able to take more cases as a plaintiff's lawyer, cases that aren't as financially or not have as much money at stake. So we're doing it both ways. We're making it easier for the pro se party, and we're making it more efficient for the law firm, which allows them to take cases that they wouldn't be able to take before.
Okay, I see that. So, fun fact, when I started my career in big law, my very first project that lasted 8 months, it was not an exclusive project, but it did take a lot of my billable time, was to actually managing multi-party service all over the world of about 57 defendants under the Hague Convention, where it applies and
Mhm.
where it didn't. And I can tell you how much it cost, because I was a first year associate at a big law, and I was spending a substantial amount of time essentially going through the chart every day, following up on all my service of processors all over the world. And let me tell you, that was not all that much fun for somebody who just graduated from law school. And I only hope that I would never have to do it again as I become hopefully a more experienced lawyer, as opposed to a more experienced process of service supervisor.
That is extraordinary, Olga, and that is a wonderful example of where technology can help us out and help us represent parties that can't afford a lawyer now. That today, proof does that. You upload the documents you want served to these 57 folks. Doesn't matter where they are in the country, the US territories, or throughout the world. AI reads them, pulls out the information we need, and then the algorithm finds the process server wherever your defendants are that's closest to each one of those defendants. It pops on their mobile app, they geolocate the nearest FedEx, documents are waiting for them, and then you track them like you track your Uber or your Lyft or your Instacart delivery person. You can interact in real time. This is where we're saving all of that Olga time back when you were a young associate. And I know in big law, you were not cheap. So you just think about that's a great example on how we are contributing today, just with one of our verticals in one of our platforms to the access of justice issue.
Okay. So, it you know, I did not like it as a first year associate. But the firm was billing me at my full rate for my services. The firm was definitely collecting money. It was not written off. I did not enjoy the experience. I mean, I enjoyed it enough when I was researching the Hague Convention and the why, when I served something in Taiwan and I didn't quite call it China, it was returned to me. It was a political statement. All of that was super interesting and delayed things for my client, but I learned quite a lot in the process. Um, and the firm collected money every step of the way. As you use technology, let's just even say AI specifically, and you can streamline it and make it cheaper, bigger, faster, sooner without Olga's not sensitivity to geopolitical issues, for example. I mean, I'm assuming you guys are more sensitive to this than I was when I graduated from law school. There is a real fear of where that, the revenue is lost. I mean, doing it cheaper for a final client is amazing, but the firm needs to, or so it feels, to pick up the revenue portion of it. So the question is, how do you have this conversation with the law firm? Because I presume many of your customers are law firms that are running a profitable business, that are used to making money from paralegals or first year associates, and they're now looking at a service like yours that they have to use, probably push by their customers, ultimate clients. And then they're looking down this pipe of AI coming, and they really have concerns. They should have concerns. What is your answer to that?
Yeah, I get this.
In your sales cycle.
So I get this question a lot from managing partners of big law, right? And I didn't get this question before the pandemic or before AI really started to become a real thing for lawyers. Change is coming. We have to change the way we do business. The billable hour is going to become less and less of the way we get paid. That seems scary. But if you do make those changes, you're going to be able to compete in what is certainly going to be a bidding process for work from your current customers, your current clients. So when you bid, like you bid on a construction project, the price sensitivity is part of the way they're going to evaluate you. And if you put in place the ability not to pay all the thousands and thousands, tens of thousands of dollars to do this job for you, then you're going to be more successful winning the work. And that's just the fact today for law firms. We're going to have to change. But the beauty is you're going to pick up some of that lost revenue on your bigger projects for your larger customers or your larger clients because you're more efficient and you're going to be able to move down and take work from folks that you weren't going to be able to take before. The stats are 85% of American businesses and Americans can't afford to hire a lawyer to take their dispute to court. $350 billion are spent on lawyers today annually in the US. That's a big number. But when you think of that's only 15% of the people that and entities that need that our services, What is it for the other 85? Is it a $1 trillion market that is not served? So we should be excited about this as lawyers. This change is going to be good for us. We just have to make the change.
Okay, well, I think it's at least nervous sighting. Maybe there is excitement there somewhere, but I think there's enough nervousness. I call that nervous sighted.
There is nervousness, Olga, but my approach and what I would like to evangelize and what I do evangelize when I speak in front of lawyers and paralegals is that this should not be driven so much by fear. It should be driven by excitement that we're going to be able to not only move into markets that we haven't been able to tap into before, but provide services, vital services to folks that couldn't afford these services before. That's a win-win that we should approach with excitement. Certainly, fear drives change, but we should be excited about the adoption of technology into our practices to allow us to do different, interesting things that better society.
Yeah. I mean, I've now had conversations about change with legal professionals for almost 2 decades in various channels from Above the Law to ACC to LinkedIn to various other places in person and virtually. And if I could summarize it, it would be something like this: everyone is excited about the change and no one wants to change. That tends to be kind of what I observe. And sometimes you have moments in history, and I think we are at that moment where you kind of have to change. I mean, internet was one of those things. Whether excited or nervous, that was changing. And I did witness a few partners who were dictating to their assistants, or and I've seen a few typewriters here and there and a few other things that seemed very prehistoric. No Pony Express, but close. And but the change was there. You very clearly were becoming an outlier very quickly, and then you were approaching retirement, and everyone who wished you for farewell. Um, and that's how that story ended. But and I think we are at the moment that you have to change. It's definitely pushing. When you talk about sort of this excitement of helping, giving access to justice, and frankly just access to folks who even can't afford but maybe don't even know about it. We're talking about a lot of tools for lawyers to gain efficiency, proof being one of them. What other things would you recommend? Say I'm a lawyer, I'm looking at 10, 20, 30, 40 year career that I would like to prosper. Clearly, you need to embrace technology if I'm not retiring in the next 2 to 5 years. What do you recommend?
Yeah, that's a great question, and everybody's listening, going, "Okay, well, what's the practical realities? Maybe I'm motivated to do what you're saying, Eric, but how the heck do I go about and doing this?" And so, what I would suggest first, and look, I managed a law firm for 15 years. I did not love technology. I wanted everything to stay the same because it was good, right? But at this point, we're going to have to make a change. So I didn't love it, but I would say the first thing you need to do, and if you don't have this yet today, then you should start looking for it. And that's adopting a case management system, right? One of the biggest drags and one of the biggest inefficiencies in practice is just the communication amongst people on your team, between you and your paralegal, between you and opposing counsel, between you and your client. Case management helps you by centralizing everything you need for each of your matters and organizing everything you need for each of your matters. And that cuts down, especially if it allows client access to your file, your electronic file. That cuts down on that communication. Every time we're picking up the phone or searching for an email, we're not being efficient. If you can limit those phone calls through your case management software, that is the first thing you should do. In addition, what case management software allows you to do is start measuring how you run your practice. Start measuring how you get your cases through your pipeline, right? Service of process to court, just for an example, gives you 90 to 120 days, depending on the state. Get service of process done. We're doing that in just over 3 days across every state and territory in the United States with a sample size of 20,000 of those a month, that alone is going to save you so much time and cost and get you to a resolution in your case faster. And that's what you can start doing across the firm if you've had case management software, because you're going to be able to track each stage. So I'd say that's where you start. There's a ton of super exciting technologies I'd love to talk about, but that is where, Olga, I would say you start.
I love that we end your recommendation emphasize the importance of communications and measurements. Because remember how this conversation started. It started with a different communication challenge at home here. We have a lot of agreement here with respect to beginning to change is now. Thank you, Marissa, for chiming in and being with us. And I love that emphasis on communications and measurement. This is independent of technology used on the back end, AI or whatever. It's just helpful. It will improve every relationship if you actually communicate well and measure your success and able to get from point A to point B sooner, quicker, cheaper. You also mentioned the word billable hour a few times. I think specifically you explicitly suggested that it is dying. It may or may not completely die. It may or may not be a glorious death overnight, but it is going into a sunset. Perhaps slowly, perhaps quickly, perhaps, who knows. I'm curious why you say that. And then even more interestingly, what are the sort of implications of that event?
Yeah, like the billable hour is a wonderful thing if you're the billing party, right? And you have an unlimited ability to bill those hours, but it doesn't promote any efficiency, right? So with the with AI and the implications of AI, it's well known. Your clients are going to demand more certainty on their side of the relationship. And that's going to just, in and of itself, going to limit how much you can just bill your time. So I foresee, and you see this already with big law and with businesses, they're requiring that you at least put some parameters on what it's going to cost them to run their case. And just by definition, that is watering down the billable hour. And I think you're going to see more and more of that. Look, the difficulty was always, how do you estimate what this is going to cost? You got a judge, you got a jury, you got opposing counsel. Who knows? Well, you can get some of the way there, and AI in itself is going to help us estimate as we move forward into the future, because there's more and more access to information that AI can help us analyze and then make predictions about future cases and how much they should cost.
Yeah, it's interesting. Folks point out the problem that it's difficult to estimate. But if you ever worked with anyone from plumber to developer, I've had an opportunity to build my own houses, and they actually have this conversation easily. Ma'am, I thought it would be this, but it's actually that. Would you like me to continue? And if so, this is your new bill. And
Yep.
it's actually, it kind of goes just like that. And I, of course, have a moment. And then I go to my husband, and we both have a moment. And then we reflect deeply on this, and we decide to continue and go forward. And after all, we look back and say, "Oh, thank God, we have a beautiful house."
Yeah. I don't want to interrupt you, but this is a great analogy, and it's one that I think about. I did a lot of construction litigation. My wife is a low-income housing developer in a previous career. And the thing that's missing is the architectural plans, right? You bid on the architectural plans, but there's always provisions for unseen conditions or for change orders that weren't in the original plans. And I think that's kind of what you're referring to. But that's a model that we can think about, right? I don't think it's in litigation, you don't have that architectural plan. You have a half of an architectural plan, but that should give you an ability to start estimating and between you and your client or prospective client, starting putting some parameters around what this should cost. That's going to lead to efficiencies. That's going to lead to better results. That's going to lead to better referrals for your services and your law firm services. So I'm sorry to cut you off that, Ogle, but
No,
I just think
no,
you're
that
spot on. That's how I think about it.
yeah, the change order there are in various industries. The change order forms are actually standardized forms, and they are standardized form for a reason because orders change mid-flight all the time in many industries, not just law. It's not only that law is the only place that you don't know what litigation will yield. And by the way, litigation could be architected through milestone pretty easily. You don't know which route it will go, but you can basically write a decision tree for most litigations. It's unpredictable which one will go, but you know what the seven possible outcomes will be. And seven is usually not seven; it's usually five or three, really. So a change of order is something that could be a concept that changes in this industry. I like to focus a little bit on sort of government and courts, which is, I guess, a unique form of government and has lagged behind in digital transformation much more than other parts of the government. What are your thoughts on impact of this AI access to justice on government players and especially courts that are key in this access to justice equation?
Yeah, that's a great question. And part of the challenge being a legal technology founder and CEO, especially in the litigation space, is that your technology is going to necessarily have to speak with or integrate with the court, right? I mean, you got to, and the court doesn't necessarily have the same level of technology or the same desire to be a technology first organization. So I'll start with that. Access to justice does depend on the court's cooperation and the court's adoption of technology. So big part of the access to justice movement, and you see it in places like Stanford University, Harvard University, and the studies they're doing and the work they're doing with courts to try to get courts to use terminology and technology that makes access to justice a real thing, makes lawyers more efficient, makes it easier for parties without lawyers to litigate smaller cases. So, my take on that is courts have a ways to go, but there is a lot of movement from various quarters. And look, everybody wants to increase access to justice. It's a real thing. It's a societal issue. I mean, it it pains me when somebody comes to me and says, "I got a $50,000 dispute," right? And it's a giant thing for me and my family or my business. And I look at that thing, they can't afford 500, $750 an hour. And how am I going to really do that on contingency? It just doesn't fit. But so we've set up the society where access to a neutral decision maker is foreclosed for that type of dispute. So not only do we as lawyers have to adopt technology, courts have to do a better job with that as well.
Yeah, yeah. We're coming to the end. We've covered a lot of ground. I have a few more questions, and I'm trying to decide where to focus this person who wants to talk about a lot of things for a long, long time. So I want to go back to your recommendations. And I love that case management, improving your communications and measure. And that should set you on your way, independent of, frankly, what the backend technology is. What other what other technologies do you think will be impactful, whether they exist today or will be coming to existence for you if you're running a legal practice, whether it's, big law, mid law, small law, government, court, in-house. I think I covered everyone, nonprofit. Did I miss anyone? I really try to be inclusive. What other technologies, and I don't mean like back end technologies. What other things will change the way we law?
So, my perspective is, or my experience is only in litigation, right? Only in trial work. And so there's some really amazing things coming that are available today and that are coming down the pipe. from a technology standpoint. And what I like about them most is they help you do things that you really didn't love doing as a litigator. For example, summarizing a deposition, right? AI can do that for you today, right? And it's getting better and better and better. And in some of these technologies, it can summarize your deposition, compare it to other depositions you've taken in this case, and compare it to the claims and the defenses, the jury instructions for the claims and defenses, or those alleged in the complaint and the answer. So it is doing a lot of the, I got to look through this deposition. I've got to, and talk about old technology, but one that I still love. I got to put a sticky note and a highlight on this paper deposition everywhere that I think there's an important piece, and I got to go look at the jury instructions and see how that fits into my case or the theme of my case. A lot of that work is being done. Summarizing evidence is being done by AI. It's a large language model. It's tailor made for that. So gone should be the days where I'm preparing for a deposition and I got boxes of documents that I've got to review and do sticky notes on. AI can get you at least 50% of the way through that and really highlight the things that you need to be focused on, the the passages, the documents, the emails, the text messages that you need to be focused on. So those cutting down the time and the agony, and I will say agony. What's beautiful about being a litigator is having that handed to you and then devising the way you're going to question the witness or cross-examine the witness or thinking about how that fits into your strategy going forward with the case. It's not reading a whole bunch of documents and searching for that needle or those needles in the haystack. So that's one thing. There's great technology to help you with briefing at the appellate level or in a motion for summary judgment, which does some of the same things. It connects the case law and then connects your evidence to your arguments. So searching through those boxes to try to figure out where the evidence that you need to attach to your summary judgment motion resides. Some of that stuff is being done for you by artificial intelligence. That's a beautiful thing. Lets you focus on what you really want to do and drive tremendous value for your client.
Yeah, I beta test a bunch of technology, including the brief writing. I thoroughly enjoy it. I have a fun fact. I was in law school. My first surprise when I got to law school is how expensive the books were. And then I opened the book and I said, wow, it has no pictures. I don't know about you. I judge the book by the cover, and I certainly will look if it has pictures. To my disappointment, the cover was not exciting, and the inside was even less exciting. It was just walls of text. So I bought myself 5 highlighters and a bunch of sticky notes and
Yeah.
expressed my creativity through that. And this is how I was recruited to work at LexisNexis Lab. A person who was working there said, "Looks like you found yourself a creative hobby." When she saw me highlighting with 5 highlighters and a bunch of sticky notes, let me help you channel that energy somewhere else. And that's how I discovered technology for the first time in law school and loved it ever since. Otherwise, I would be that person howling all my sticky notes and highlighters everywhere I go. And thank God I didn't have to do that. But yes, I played with a lot of software. I still play today that allows you to sort of automate finding the evidence and cut and paste things and kind of suggest what goes with what. And it's just mind blowing. It's so exciting.
So
It's
exciting.
transformative. It's not just exciting, it's transformative. It really just, I agree with you, allows you to focus on the strategy, kind of how you approach this person, how you approach this argument, how you approach this judge, how you ultimately win. I mean, you spend your mental energy on things that matter as opposed to, expressing your creativity with highlighters, which is what I was doing in my year one of law school.
You are giving me the chills. I know your background is being, you had a desire to be in a creative, profession, and I think you're using that now. But you're giving me the chills about the real win-win here. I mean, who wants to look through a box or search through a bunch of PDFs to find the evidence that you know is there because you've been working on the case? And who wants to pay $500 an hour for somebody to do that? That stuff is being eliminated, and it's wonderful. It's going to be much better to be a lawyer when you can focus on the really imaginative, creative things that you can do in a case. So,
Yeah.
yeah,
Yeah, no,
well said.
that tactile experience of doing things with your hands, it kinda the excitement of it goes away in about 3 documents, and then you're just left with paper cuts and looking at I actually had a bunch of boxes in that same law firm that made me serve 57 prospective defendants. I also had boxes in my office that arrived continuously, and I was sorting through that stuff too. That's how exciting the first year associate job
I
was.
know.
So,
I did it
yes.
too. Musty warehouses, dusty documents. I did a bunch of environmental litigation, so I was always like at these circle of landfills, searching through barns full of documents. Yeah, no, thank you. We don't have to do
Yeah,
that anymore.
I mean that failed career in being an archivist was like a real thing. Um,
Yeah.
go ahead.
No, that was I was just saying yes. I agree with you. I love the way you put this.
Yeah.
Yeah.
So maybe one more thing. Let's talk about paralegals because lawyers and law firms bill for paralegal time too, and sometimes the answer for the things I don't want to be doing, like highlighting, looking through documents, and all of that, is the answer is paralegals. And then, of course, depending on paralegals, they also may or may not enjoy it and may also be pushing for change. I've seen activist paralegals who basically were fed up with paper cuts and other stuff and were advocating for various change, including technology. Curious, what is the role of a paralegal? How will it change? And what is their role in driving this digital transformation in a law firm?
Look, paralegals will remain the unsung heroes of law firms. They are the backbone, right? They get the job done for us. They do the difficult work. They are keenly aware of what technology is out there. So listen to them, right? As a law firm owner, a law firm manager, or just a lawyer in a law firm, please listen to your paralegal. Ask them to find the technology that makes their job better. So then you can elevate them in the case to drive more value for your client. So they should be doing some of the investigation. They should be interviewing some of the witnesses with you or without you. They can't do that if they're getting those paper cuts and dealing with sticky notes all the time. When people ask me what can be done with access to justice, it's two things: demand the best technology and adopt the best technology, measure your usage of that technology and how it improves so you can iterate. Number two, elevate the paralegal through adopting that technology so the paralegal can drive more throughput, more cases, and allowing you to represent more folks. These are unsung heroes and underutilized individuals. I think their role is just going to grow. They're better technologists and they can do a heck of a lot more than we allow them to do today. Maybe there needs to be some modification of what it is to practice law. And you're seeing that in some states where they're allowing paralegals to do some things that maybe were the practice of law in the past in certain levels of case, certain substantive areas of the law, in certain um, jurisdictional limits, right? Can't be over $50,000 at stake in a divorce case for a paralegal to do these additional things. So, two things: one, adopt that technology, and then two, elevate your paralegal. Use them wiser for to drive better value for your case and your clients.
Great insight. We are at the end, and I thoroughly enjoyed this conversation, especially because the depth and breadth of it. What is the one thing you want folks to take away or do after they listen to this?
Look, change is hard. I don't, didn't want to change. It's been good for lawyers, but the time is now. The pandemic, the great resignation, and AI have shown us the power of technology. Don't be afraid of it. Let's grab this thing. Let's grab this opportunity. It's not going to run us out of jobs. It's going to make us money while we increase access to justice. But you gotta embrace that change and you gotta do it. And the time really is now. So that's what I'd leave you with.
I love it. And that's a great place to live. Thank you, Eric. Thoroughly enjoyed this conversation. I am so glad that we didn't tether through my phone and I had a full non-mermaid presence in this conversation. And thank you, everyone, for joining. Thank you so much for being active. I'll see you next time. Bye, everyone.
For stopping by. We hope you've enjoyed this episode of Notes to My Legal Self. The future belongs to builders. Know someone who'd make a great guest? Let us know. Self-nominations are encouraged. They're an act of courage. Keep in mind, the future of law is all lit up. Let's roll up our sleeves, innovate, build, and change the world of law together. See you soon.